because that necessarily disturbs the speaker and also those who attend it. That is my request. If there are people who will come in, so we will not executively be able to allow them to come. All right. So we start with the, after having had an introductory class, I will quickly take up questions or reflections, if there are any, on the basis of the class that we had the other day by way of introduction to the law of interpretation. If there are none, I presume, and I proceed with this, the next class. If there are any questions, you are most welcome to ask any time during the discussion. I request you, if there are people outside, so ask them to come in if they want. If they don't want, you just close the door. Because last time we had this difficulty, we allowed people to be responsible, but they sometimes destroyed the class. Keep coming, you see, until the end. You see, did you receive your readings? I think there was a mail ID of your LLM class. I was told that everybody would receive if sent to one single email ID. If you are not still receiving the readings, you are most welcome to get back to me by your individualized email IDs, and I would not see mind sending you your individual email ID, because it costs me nothing, because I'll have to just paste all those emails addresses, and that will not be a problem. So please tell me, did you get the readings or not? Yes. You got it? That's right. Let us start with this meaning of interpretation. That is our lecture 2. We have to go a little quickly because I presume that we would have 2 hours to finish this talk. In any case, let us see how fast can we go. So the first thing that you need to know about meaning is, meaning has little to do with law, more to do with the language. Obviously, law is a social science. It needs a language, just as any science would need a language. Law also needs a language in order to be communicated. And at the very beginning, this is very important to duly appreciate the significance of a language when employed for the purposes of communication of a thought. Here in this case, we have to communicate the thought of interpretation, and therefore it is quite correct to say that no meaning is independent of its meaning in the language of its communication. When you say there is a meaning, you presume necessarily that there is a language. You do not reflect upon the language. But upon reflection, if you think, there certainly is a language in which you are communicating. You don't have to say. When I am saying, I am not saying that I am speaking English, but you are aware of it. Whatever words I am using, whatever grammar I am using, that is English grammar. The moment I switch over to Hindi, you know that I am speaking Hindi. You also know that I am necessarily relying on Hindi grammar. I will very quickly give you a very simple word, and then that will underscore the point. In English, we say you, Y-O-U, whether the person is of our age, junior, or no matter how elder. In Hindi, we use at least 3 translations of you. Aap, tum, and tu. Now, try and understand. Can you exactly translate these 3 Hindi words into English? Please tell me how. If you say aap is equivalent to you, all right, accepted. What is the equivalent of tum? Therefore, and this is a very simple example. This is an example that we use every day. So therefore, it is very important. So the point to underscore is whether or not we are conscious about the language, we are perforce instinctively using a language. Further and consequently, we are also using some grammar, even if incorrectly using. An incorrect use of a grammar is a use of a grammar. We are not saying whether we are correctly speaking the language or whether we are using correctly or correct grammar. We are certainly relying on it. In other words, let me give a subconscious thought about the grammatical rules. When we talk about a story, when we refer to a thing that happened in Allahabad when you were a student or which happened in the school, you have a different tenses, you have a different vocabulary and different things to use. When you talk about today, you use different tenses. I'm not saying that you use it correctly always, but you know it that you are talking about the past. You know it in the second sense that you are talking about the present. This is the point that you need to understand, that the meaning of interpretation is necessarily dependent upon the language. If you translate all my talk into Hindi, believe me, I'll have to correct the translation. Because I will not say, I will never be able to agree on what I said in English. The reason is very simple. I am a 100% Indian, but I did not study law in the Hindi language. That's the point. So I can never be sure of the translation. And there will be some words which I will refuse to say that you ascribe to me in Hindi. I will say, well, you write it, you write your name by translator. For instance, tum and aap and tu, all these things. I may use you and you translate it to tu, and I said I would never agree to it because this is derogatory. This is defamatory. This is a misconduct. If it is spoken, you see, you have to assume it. So this is very important about this. That is the first thing. Therefore, let us see if this is the assertion and you agree, then there is a deduction. I hope you understand this inductive and deductive reasoning. By now, I think these are three fundamental things, whether or not you talk about it, but you use it. This is again, in our talks, in our arguments, we use these reasonings, whether or not we are aware of it. Here is a statement, first one, and therefore it is in the indent, and you can see different colors, so you can make out that this statement, the way these are written are different, and if you apply some analogy, you will find out there is a difference. Second one follows from the first. First one is a general statement, and that is going to be the presentation in all my classes. If you just focus it, you will find out what is happening. Second statement is called a deduction, based on the assertion that is in the first sentence. In other words, if the first assertion is incorrect, the deduction perforce is going to be incorrect. No deduction can correct the assertion. But converse may not necessarily be the case. An assertion may be correct, but deduction may be wrong. Why? Because there may be more than one deduction first. The question then will be of choosing which is the better, more appropriate deduction. So we said that no meaning is independent of its meaning in the language of its communication. If this is correct, then it follows that meaning of interpretation is therefore inseparable from its meaning in the English language. Certainly we will be using in the English language. And therefore, whatever we are going to be saying about interpretation, that is what we understand, speak of, refer to and understand in the English language. What is English language? Very roughly is the English language which we adopt and which we believe to be a standard one on the basis of what is its development at Oxford, communicated to us by the latest edition of the Oxford English Dictionary, that is UK English, not US English. Grammar Well, there are a number of books available. I will, if you ask, I will tell you about those references, but I am not aware of any grammar book which has got such an official status as of the English dictionary. So that is how we will proceed. Shall we move forward? Yes. Okay. The second background in order to understand the meaning of interpretation is another assertion. No language can communicate meaning without operation of the rules of its communication. There are several rules of communication. You can say a thing in present tense. You can also, say it in continuous tense. You can say it by usage. You can say it by idiom. Example, please do it in due course. Please do it at appropriate time. Please do it in an appropriate manner. Now, second and third examples are absolutely exact. Because in one way, you are talking about manner. In the first, you are talking about time. But when you are speaking the language of idiom, in due course is a phrase, idiom. This is not etymology. This is vague. This is not ambiguous. This is vague. When we say we do it in due course, the person who is writing it doesn't want to be exact. Or maybe he doesn't want to restrict your liberty. He would like to give you more freedom. Because he did not say do it in an appropriate time. He did not say you do it in an appropriate manner. He said you do it in due course. Due course may be after half hour, tomorrow, day after tomorrow, after 1 week. Let us get back to the point. Speaking in a phrase, in an idiom, and in etymology makes a lot of difference. Sometimes, and I would say in conscious writings, it is a matter of choice. It is not that the author doesn't know. You say, do it in appropriate time. He doesn't want to do it. He says that we do it in due course. So therefore, when that expression is given, in other words, the intent of the speaker is very clear, or the author in the text is written. That from his side, he doesn't want to be more precise. The effect on you is, to the listener or to the addressee, that you have more flexibility, more freedom. Let us see, even more exact expression is of saying that you can appropriate time, do it by tomorrow evening. Imagine, if this is the statement, and if you don't do it by tomorrow evening, you know the consequences. The language can still be further. Do it by 7 p.m. tomorrow. Then even evening, the vagueness that is embedded in the word evening, that is also gone. So what I am saying is this: all these things, you have a range of options here. So when you see, as a student of interpretation, now you will be very conscious. When you read these expressions, you know what is the intent. If it is evening, 7 p.m., due course, appropriate, all these have things. And when spoken of, written, or in the context of law, in the context as part of judgments, then you can imagine the importance. If these words are used in a treaty or a contract or a judgment, then the importance is all too much. That is the point that you need to remember. Therefore, the English language cannot communicate the meaning of interpretation without operation of the English language, grammar, and other rules of its communication. After writing grammar, I added other rules because if you see grammar books, let me tell you about some grammar books. You see, starting with high school, Wren and Martin, slightly higher, Thompson and Martinez, graduation, university level, Fowler, Eric Partridge, all these. Then Collins, I would say standard usage, Thompson and Martinez is a very standard book for an elementary grammar. For usage, there is no better work written than by Powell. That is amazing. But that is also very difficult to read because sometimes details would make it difficult to read. So if you get hold of Eric Partridge, that is equally authentic but a more readable version of Eric Partridge, usage and evolution. So in other words, if you see the table of contents of all, there are several other scholars. I would not like to tell you every other usage grammar. These are the standards. The problem is the table of contents of these grammar books are not identical. Some would include figures of speech, some would not. Then sometimes figures of speech are also used in communications. If you do not know this, then you will miss the point. It is time to go to a movie. It is time we went for a movie. It is high time that we went for a movie. Do you know the difference? In all these three sentences, you are communicating. If I tell you the meaning, you will be surprised. The first says it is the right time to go to the movie. The second says we are already late for a movie. The third says we are very late for a movie, as though half of the movie is gone. This is about usage. So if you read the second sentence by the simple grammar, you would conclude that it is written incorrectly. Because the first clause is present tense, how can second be in the present past? That is not the case. So, usage would not necessarily be justified on the basis of grammar. Grammar and usage do not always go together. By usage, the language accepts as incorrect what on the basis of grammar would probably be incorrect or may well be incorrect. So this is very important. And as we go by, as we would see references, I will try my level best to tell you and give you illustrations of the best top courts like ICJ or WTO appellate body to actually see in a context the significance of grammar, present tense and present perfect tense. In a context, when it determines the obligations of parties, it is no longer a matter of tense. It is not longer a matter of elegance of it. It is actually definitive of the competing rights and obligations of litigants. So please try and understand. You may debate the degree of importance of grammar, but you can't deny the importance. That is the second point that you need to underscore by way of this. Let us move. Now we are coming to law. The third background point that you need to remember is that interpretation is part of adjudication. This is the assertion. Anybody who disagree with this assertion? Do you believe that there is interpretation which is outside of adjudication? Well, one might say very quickly that sometimes a tribunal is asked of an advisory opinion. But taking, you see, a broader view of interpretation, I would include advisory opinions as part of adjudication. It is only in the restrictive sense what you consider as contentious proceedings. If you visit the ICJ website, you have cases into usage slots, contentious and advisory. But I think you can take it as part of adjudication. Because the difference is, in an advisory opinion, a point is decided hypothetically, which is not actually before the court. In a contentious case, the point is actually before. Advisory opinion do sometimes and have sometimes prevented some actual cases going to the court. Contentious cases do actually settle cases which have already gone to the court. But the difference is not so stark as to exclude advisory opinions from the category of adjudication. If we do it, the loss for our discussion would be that we will necessarily have to exclude many a good advisory opinion from our discussion that we don't. Then, if this is the case, that interpretation is part of adjudication, then this follows that a proper study of interpretation is inseparable from some study of adjudication. If you read a case, it is not possible for you to directly straight away go to that point of interpretation. Even you can use your words and search engine and that will pick up some interpretation points. Just highlight those points, copy them, paste them on a clean piece of paper and then read from start. What will you understand? Nothing. Nothing. You know what will happen? You will end up copy and pasting 20 illustrations, 20 times interpretation has occurred. What does it mean? You will have. That is why I have much difficulty and much thought in choosing the determiner sum. And how much study? I said sum. It is not possible to be more exact at this. We may agree how much you study, but simply by cut and pasting interpretation, you won't understand. And if you do have to do something more, then you have to agree that you have to study something more than that. And we have two cases to discuss today, and we will testify, usually we will test our hypothesis in those two cases. So this is something which is very important. Problems of interpretations do not arise in abstract. They arise, you say, in the context of adjudication. There, you see, we are not discussing forms of adjudication. For instance, when a human rights committee is, you say, you read Sun's book and you will find, you see, the entire book is a human rights committee. So the nature of adjudication is different. You have reporting by, you see, you have complaints by individuals, you have deliberations by committee, you have, you see, decisions by committee. It is a form. The only disagreement is the form of adjudication. You are not saying adjudication and forms of adjudication. There were different forms of adjudication. You go to a human rights commission, it is different. You go to Supreme Court, you go to High Court, lower courts, there are different forms. Adjudication means that there is a contentious point, you see, put forward by two parties, different, you see, and then there is some resolution, there is some, you see, pronouncement given by a body, however body, it may be a committee, it may not necessarily be a court.
So what is the difference between versus and slash in ICJ cases? Like Bosnia and Herzegovina versus Serbia and Montenegro versus?
Yes.
In between.
And slash.
Slash.
Yeah, very good question. You see the difference is, yeah, I got it. The difference is when the expression versus is dividing the parties, which means that there is an applicant state and there is a respondent state. The first is an applicant state, the second is a respondent state. When a slash is dividing, then alphabetical order is used to divide the parties. And which is enough. Why? Because there is no applicant and no respondent. The case has gone to the ICJ on the basis of a compromise. Sovereignty over Pulau Sipadan and Pulau Ligatan, Malaysia and Indonesia. So there was no applicant and no respondent. In other words, the consent to ICJ jurisdiction was not ante-form, it is a post-form. The form of consent. Only the form of consent, not consent. Consent is included in both, in other words, the jurisdiction is essential. So that is what it signifies. Then, if interpretation is part of adjudication, and we have agreed that some adjudication is required, and that is why we have moved forward. If we disagree, there is no need to study any adjudication and we can understand interpretation. Then obviously this slide will be hypothetical. Then, adjudication requires law finding. Adjudication of a controversy according to law necessarily requires law. Can you settle a controversy if you are an organ of law or are required by law to apply the law? Settle the controversy without finding the applicable law? This is the question. It is not. Now, if that is the case, it does not mean that finding of a law is interpretation of law. Law finding is not interpretation because it precedes interpretation. In order to interpret the law, you must have the law. So, law finding is a prior stage, it is a stage anterior to before you can interpret it. That is very simple logic. So, identify the law. Which law is applicable? People who have gone to domestic courts, you write in the writ petition grounds. There you identify the law. In pleadings, well, CPC is not very correctly observed in this country. You are sometimes, courts are lenient in allowing parties to elaborate arguments. Otherwise, you have to only state facts. There you can interpret. Or even the grounds themselves, you can write first the law and then you can write your interpretation. Or you can find out some precedents of courts, put them in the grounds, interpreting the law that you want the court to apply to the facts of the case. The point to underscore is, identification of law is necessary for adjudication, but is not synonymous with interpretation. Why? In order for the law to be interpreted, it has to be identified. Therefore, in terms of elementary logic, law is to be found first before it could be interpreted. Then, adjudication also requires law application. It is not enough that you have found the law. You have to also apply it. Why? Because your law finding is complete as soon as you have identified the law. But mere identification is no application. The reason is very simple. Law is made in abstract sense. 1930, Indian Sales of Good Act would say about late delivery. Vienna Convention 1980 would talk about late delivery, sometimes amounting to fundamental breach. But could you tell me the late delivery that is there in Article 25 of Vienna Convention or 49 of Vienna Convention amount to fundamental breach? Does it say anything about what constitutes to be late delivery? Does section 300, talk about in how many ways, murder can be committed? It is not possible. A definition is definition because it is not an enumeration of facts it intends to be definitive of. So, the point to underscore is, law by necessity has to be as it is formulated in an abstract. And courts decide cases which are real, unique. I remember Roscoe Baum, the chapter that I asked you to read, chapter 3, application of law philosophy of law. Perhaps the last sentence or the second last sentence of chapter 3, he writes, no two cases are alike or will ever be alike. There must be some difference. Let me also tell you a classic statement by Heraclitus. You know Heraclitus? Predecessor of Plato. correct like this. He made a statement very profound. I will also use it in the next class, but it is also important to use it here. He said, you can never visit the same river twice. You know what is he saying? Even if you visit a river after 1 minute, that's a different river, because the water you are visiting. Forget about 2 cases. Well, that requires at least half an hour explaining why 2 cases are important. But presuming you will have chances to further explain. So many things change one judgment to another. Now, law application is not interpretation. Why? Because once you have interpreted the law, only then can you apply it. In other words, law application follows interpretation. It is the next stage. It is a stage that comes after. So sometimes you may have interpreted the law correctly, but while applying it, the court may have fallen into some error. There are people, when you solve a maths, you see a question paper, you may know correct formula, but you apply the correct formula, and the result is, so your application is incorrect. Identification of formula is correct. So it doesn't follow that if you know the right principle. If that is the case, then everybody who has a good pen, or the pen that can write, will all write answers and pass on that. Same pen you use and you may fail. Same pen you use and you may top. So that is the reason. You see, try and understand. Application of law is different. Knowing the law is different. So these are other stages. So with this background, let us come, to two fundamental, findings of today's class. And this is a summary of some of what that has preceded. Adjudication requires determination of the meaning of the legislature or enacted law, or parties or agreed law, or the meaning of the enacted or agreed law, for its application to the unique facts of a case. This determination is interpretation. Let me explain a couple of things. We have already said that interpretation is a stage that comes after identification of law. It is a stage before the application of law. Legislature enacted law we have used. The reason is, if you see the literature, there is no unanimity in the literature that when you talk about intention and you use the adjective legislative intention, so the adjective legislative doesn't necessarily refer to the legislature noun or the nature of the law, enacted law. That is the reason I have included both, because I could see the literature is overwhelming on both sides. Parties and agreed law, why? Because we do not focus or confine our discussion only to domestic law. We would necessarily include international. So international law, parties and agreed law, that means treaties, agreements. Or the meaning of enacted law. These two streams are there, whether intention or meaning. Legislative intention or legislative meaning. In terms of international law, intention of the treaty or intention of the treaty makers, drafters, or parties to the treaty, to be more exact, or the meaning of the text, meaning of the agreement. We will explain here, don't worry about it. This is a statement and we will explain it. This is interpretation. So because this determination is interpretation. That you have arrived at what you believe to be the intention, whether it is of the legislature or of the legislation or of the treaty or of the treaty makers. On the one hand, if you are intention centric, if you are meaning centric, than the meaning of the legislation or meaning of the context. Certainly, this product, this result is interpretation. And this result is to be reached before the law would be applied to the unique facts of the case. Then, before you reach this process, reach this product, you undergo a process. The whole exercise, a writ is filed, the judge goes home, reads the petition, marks certain points, comes to the court prepared, asking parties questions, passing interlocutory orders, waiting for pleadings to be completed, allowing for the final dates of arguments to come in, hearing the parties finally, reserving the date for pronouncement of the judgment before he has to write it. What is this process? Does it happen in one day? Anybody who has had only one experience of any judicial process, one experience is enough. Anybody who has at least one experience of any judicial process, first hand experience, not through a lawyer. Anyone? Nobody here has any one experience. So then you have to rely on the experiences of others. There is no other option. And you can do it. Let us go to ICJ website. See the date of filing of the application and see the date of the judgment. And in between, see what are that? Long drawn out process. Sometimes decades. And that is, see, not ICJ. Some very famous cases in India, more than 30 cases, 40 years. What is this? This necessarily is a process. This process, if it is spoken of in the context of and with reference to interpretation, is certainly interpretation. Because you cannot reach interpretation without appreciating this process. And this is a judicial process in most cases. Because just as we have included adjudication, also advisory proceedings and proceedings of those bodies which are actually not wholly judicial bodies, maybe Central Information Commission, Human Rights Committee, or National Human Rights Commission, or several other bodies. These two would include those. But even if a body which is not a judicial body, this process is a judicial process. Because this cannot be a biased process. The minimum yardstick of a judicial process is minimum yardsticks, those fundamental principles of natural justice which I am sure you are aware of. Odi alterum partem and nemo debet esse judix in propria causa. The person hearing you should have no interest. These two fundamentally is irreducible. Because if first is present, you don't have interest, but you don't hear one party. That is equally bad. One party has made an allegation against you, and the tribunal has decided. You just think about it. What will you call that process? And the judge says, well, he is not my brother. I am not related to him. I have never seen him. Fine. What are you arguing? You are saying that you have no personal interest. I agree. You are honest. But you see, your honesty is not enough. If a judge is honest, it is not enough. If that were the case, the qualification of good judges would be that they must be saints. Isn't it? But that is not enough. Never in the history. The question is, you have to decide between the parties who is correct. And in order to decide these competing claims, you must hear both the parties. And hearing means opportunity to put forward evidence either of a claim or of a rebuttal. If say that you committed murder yesterday at 3 o'clock and you have your attendance signed in a written list where you were attending Professor Jaggi's class, you are not given this opportunity because that evidence, if that is admitted, is sufficient to acquit you from this murder case. You know, important. Why? Because you were never given this opportunity. So murder, oh, must be contained. So this is what is called a judicial case, which means that you hear both the parties and you should not have your own views. Let us, after having seen that these are the two, you see, one is a product and another is a process interpretation. Let us now explain, because unless we explain it, it is not possible to understand this and you will forget very soon. Explanation number one. Interpretation as determination of intention. Let us see some of the writings, best known writings. This is not exhaustive, and I told you, we don't claim that we will be able to discuss all studies. That is impossible. Some of these writings, for instance, if you refer to Salmon, you see, talks about sententia legis. And he is referring to the expression that he has used. If you read, refer to, you see, Judge Posner, Richard Posner, he talks about imaginative reconstruction. And you can find these expressions in the readings which I have already shown to you. Those readings. So I have taken these things from those readings. That is courtroom and the classroom interpretation. Imaginative reconstruction. Then you come to, you see, Justice Antonin Scalia. He says legislative intention is objectified by statutory words. He is saying in the absence of statutory words, legislative intention is subjective. Subjective in two senses. First, it is unclear whether this is the intention of the legislature which has enacted the law. Even if it is true, then the problem will be intention of whom? Those who voted for it, obviously. In other words, excluding the intention of those who did not vote for it. Second, intention of those who had voted for it as embedded in the legislation. Third, how do you get to know this intention? Can you meet somebody, or the person is Stephens or anybody, or Macaulay, or and I don't know how many people, who drafted section 300 like this? Can you meet these people? So how do you know their intention? It is very difficult to know the intention of your friends. For I am saying people whom you know and regularly meet. Forget about those people whom you have never met. The whole question is this: even if there is agreement that this intention realistically could be not of those who have made the law, but what they have made, legislation, it is still insufficient. Why? Because this does not answer the question. That how do you get to it? Means, how do you reach? You have never seen them. You don't know them. There is no correspondence between you. I mean, you mean the judge who is applying that section 300 and the one who has made it. Then how do you know his intention? Please be realistic and accept the only link between that person or a body of persons or whatever and the judge is section 300. And that is what Scalia is talking. In the absence of words, this is very subjective. It is very tenuous. It is very controversial. So that is what you see. You can see progressively. Salmon, you see, he is one author, I am sure, people from LLB and upwards. Salmon's jurisprudence, I am not saying the only book, but there is, I think, one book which It's very difficult for me to presume that students of law are not aware of it, not heard of it. That's the reason I have chosen it. There are many I could have chosen. Posner is important because for several reasons. Scalia is obviously one of the best known judges and certainly US Supreme Court judge. I know no better serving judge at a higher level than Justice Scalia, written so much about interpretation. That's the reason I have chosen it. There could be many more. Well, of course, we will talk about it. Explanation 2. Interpretation as determination of intention. Here we will come to a case that I asked you to read. You see, when you read a case, I think 3 things you must know. If you do not know these 3 things, I think then reading a case and reading a story would make no difference. A case is no story. You must answer 3 things. What are the relevant facts? I tell you the importance of the word relevant. A case may be read, the same case may be read for different purposes. So those who, you see, drafted this judgment did not say that it could only be read for an interpretation class. So therefore the importance of relevant. Relevant means we are reading it for interpretation. Find out relevant facts. Then relevant issues, there may be many other issues. For instance, we are not concerned with boundary dispute. This case would be a very good case on delimitation of boundaries. That is not our class. So see the relevant issues. We are not concerned with those issues. Then relevant findings. There may be several other findings. In other words, this case is basically deciding a dispute of a boundary, but we are not discussing it. Please recall these three things. You have read this case. Case is with you since Monday, 8:30 onwards. Not a long case, maybe 18-19 pages. What was the relevant fact? What was the relevant issue? No idea. Anyone who has read this case, please quickly, otherwise you move forward. That's not a problem. Any finding that you may recall that was made by the tribunal? All right. Well, for your help, these are the 3. The relevant fact was it was a delimitation of territorial possession. At least this much you have to appreciate. Minimum. The relevant issue was interpretation of the 1904 convention. I am not saying it did not entail interpretation of other treaties, but this was the most important. Why? Because this was the last of all treaties which were the subject matter of interpretation. This was a treaty which confirmed the intent of the parties to the treaties preceding it. What was the finding? The most relevant finding of this treaty, this commission, this arbitration, was that interpretation of treaties ought to be made in conformity with the real mutual intentions. There are 2 adjectives used. Real. In other words, not abstract. Mutual, which means not the intention of one party, both intentions of the parties, rather than by relying on inexact expressions. The tribunal is not saying that you don't rely on expressions. The tribunal is saying that you don't rely on inexact expressions. Because if you read it, the tribunal is saying that you don't rely on expression, then the word inexact was not required. then making a concrete finding. Concrete finding was that line A and C, from point A to C, because this dispute concerned delimitation of territorial position between Portugal and the Netherlands in the East Timor island, that point A to C should be considered in the intention of the parties as a concession made by Portugal to the Netherlands. You see, it was a situation more or less like the case of Temple of Pre-Bihar case in the original proceeding 1962. More or less, I'm not saying 100%. The reason was this. Just as Thailand did not protest after the map was accepted on its part for Cambodia, just as in this case, Portugal did not object to this line. Rather, in all its correspondence, Portugal stated it without objecting. Dutch, of course, stated because it was beneficial to Netherlands. Now, suddenly you can't say that when you realize the loss, the harm that it would do to you as a state, that this line is not accepted. This is a very fundamental principle that you know even by way of evidence, that is the principle of stopping, preclusion. Then by your conduct, you allow other party a concession, allow other party to rely on the fact situation that you have created. So that is how you see it was. And on this point, it is so difficult, I tell you. It is not an easy reading, 20 pages, and to find out what is the point. On this point, you go home, you see, on this point there was absolutely no disagreement between the parties. Portugal had no answer to this point. On several other points, they have all disagreed. So this is how. So let us make again read this, the last point. The court is not saying, even when appreciating the necessity or deciphering intention, the court is nowhere saying that you disregard expressions. Why? The word expressions is qualified by an adjective called inexact. And if a tribunal refuses to appreciate inexact expressions, it is not that the tribunal does not want to appreciate the letter of the law. Obviously, inexact expressions need not to be referred to. In a course of three, you can find out, read, and where you can find, and there is no conflict, no disagreement. And on this point, there was no disagreement. So, court disregarded all other expressions, agreed on this, and A to C. This point, I tell you the exact, if you have read this case, you would see at one point the court is saying, you are referring to a river. Well, while describing the river by its name, you have used an inexact expression. Now please tell me, where is the intent of the parties missing and where it is present? Inasmuch as both are referring to a river, to that extent that there is no disagreement on intent. But insofar as they are using different expressions to refer to a river, there is disagreement. So what you as a tribunal you can include, appreciate, and what you can disregard. You disregard their expression. You can correct that. But you agree, yes, both agree, because their reference to point C, points on point C, so point from river. Or on this point, there was absolutely no disagreement. But in some passages, in references, the court did find in the manner of referring to the river, you see, incongruously by both the parties. That you will. And that is what the court is saying, that you refuse, disregard inexact expressions. Now let us come to India and see Indian context. That is a case you can more, much better way you can relate to, because this is a case of a recent case and with your law background at the LLB level you can appreciate this part. Interpretation as determination of intention, third explanation. Second case, I.R. Coelho case, 2007 case. Again, whenever we discuss any case, we will do it in this manner. Otherwise, this is going to be totally a story talk and that leads to nowhere. Again, the relevant fact. What was the relevant fact in this case? When did you do your LLB? Constitutional law wasn't a subject. No?
Yes.
Fundamental rights?
Yes.
Basic features of the Constitution? Kesav Nanda Bharti case?
Judgment, I know, sir. Judgment of this case, I know, sir.
You know?
Basically, sir.
Yes, please tell us the relevant fact. Okay, tell us the relevant issue.
The laws which are there in 9th schedule, which are put in 9th schedule, are subjected to judicial review or not?
Yes, more or less correct.
And the basic thing was that basic structure issue should be considered after what? After which year? Those laws should enjoy the protection of judicial review after what? That is from the date of judgment of Keshwan Bharti.
Yes, exactly. Yes, that is about the second issue. So second issue you have, you know something. First you are not aware, and the third, what was the court's finding?
That the laws which have been enacted before the judgment of Keshwan Bharti will not be subject to judicial review, but after that judgment, all those laws which are being put in 9th schedule will be subjected to judicial review.
Yes.
They are open to challenge.
Because judicial review is the basic structure.
Yes. Let us see. Now you remember these things and let us see for your convenience. The relevant fact was inclusion of laws in the 9th schedule of the Constitution after 24th April 1973. Wasn't this a relevant fact? 24th April 1973 was the date when Kesav Nanda Bharti judgment was given. Why was it the relevant fact? Because all other laws which had been included before the date were presumed by the court to have been consistent with the Constitution and the basic feature theory that it propounded in Kesav Nanda Bharti case. But I am only saying presumed. Second, if you read this judgment, the court did not even presume that Article 31B was constitutional. I repeat it, the court did not even presume, because the court only assumed. Do you know the difference between presume and assume? Do you use it interchangeably? As a lawyer, you should never do it. Yes. You see, when you say that there is presumption, which means that there is a prima facie case. A prima facie case is one which, in the absence of an effective refutation by the respondent, would require the tribunal, as a matter of law, to rule in favor of the claimant, petitioner, or whatever. That is presumption. And you know what is assumption? When there is not even a prima facie case. Now revisit in the concrete case. Article 31B was only presumed to be constitutional by I.R. Coelho case, and that is why it is a path-breaking case. From 1973 to 11 January 2007, people presumed it, or many actually believe that it was proved as constitutional. The reason why it was only assumed, why? Because this was not a question before the court. Had it been a question before the court, and even in the absence of the court pronouncement on this point, we could have said that it was presumed. When there was not a point. When there was not a point, there could never have been, as it was not, a finding. Even if there was a finding, it would be odious, particularly. Injury. So the point is this, it was only assumed. So court is not saying that Article 31B is constitutional. Simply assuming it. Yes, presuming those laws which were put in the 9th schedule before 24th happened. Presumption and assumption, well, I'll explain to you, but please allow me to continue the class. I'll explain to you. Because others may not usually, they know about it. Do you want me to explain this point?
Explain, sir.
You see, the difference between assumption and presumption is, presumption being like the prima facie evidence. There was evidence. Some evidence. Assumption, there was no evidence. In the concrete case, Article 31B was not challenged in case of that. Since it was not challenged, there was no finding. And therefore, a point which was never challenged, a point there is no finding, therefore, how can it be accepted as constitutional? I.R. Coelho did not say it, why it was again not challenged. Maybe they presumed it. Those who drafted the petition, that it was constitutional, there is no need. Maybe they did not want to broaden the scope of the petition. That is also a point, that is also a tactical strategy. Because the point was, in this case, to be more specific, there were legislations which the Supreme Court had already declared to be ultra vires the Constitution. When they were enacted and they were challenged before the court. The executive did not like it. Executive said, okay, so you are declaring our laws to be unconstitutional, all right. We are going to put these laws into 9th schedule and then hell with you, what will you do? I am just, simplifying the language for you to understand. That is not a formal language. That was what was happening. So they passed the law, it went to judiciary. Judiciary said, no, you can't do it. This is illegal. They said, all right. These illegally declared law were put in the 9th schedule. As if it is a bunker, where F-16 can enter. That is sort of the thing that they did. So the question was, can you put illegally declared laws, which have already been adjudicated, into 9th schedule? The problem was, in other words, in fact, on merits, there were actually no second adjudication required. The second adjudication was not required on merits. The second adjudication was required qua constitution. And qua constitution, qua basic features. Because these laws have already been challenged and were declared as illegal. Then the judiciary got, totally scared. See, this is what you are doing. We declared laws illegal. You again put them in this. So does it mean that here is a scapegoat for you that which will immune anything that you will usually declared unconstitutional? Because you believe that this 9th schedule is so sacrosanct that nobody can challenge it. It is here in this context that this issue came. And then The Supreme Court in this case, relying on its prior jurisprudence developed in certain other cases, more clarifying in this case, devised a twofold approach. Well, I am going beyond the point of interpretation. That is, I should not explain because these are constitutional law. Twofold approach: the essence of the rights test and the rights test. The rights test, right plural. And in the first, the essence of the right, singular test. In other words, the difference is when you put a law into the ninth schedule, intending to immunize it from a challenge and block from fundamental rights, then the rights test would apply. When you put a law in ninth schedule that infringes only one, two, or some of the fundamental rights, then the essence of the right test would apply. The reason is, the question then inquiry would then be, how much of the right that he takes away. And therefore, essence of the right test. Does it take away the essence of the right? Or does it merely, regulate it? For instance, read Qureshi cases, cow slaughter cases. Three Qureshi cases. That is the point. So this is what the court said. So therefore, the relevant issue was whether the basic structure test would include judicial review of ninth schedule laws on the touchstone of fundamental rights. That was the relevant issue. And the finding which is relevant for interpretation is, read the first two expressions. The court said, original intent of Article 31B was only to protect a limited number of laws. Read the word original intent. So here you see, intent is qualified by the word original. So you have qualified intent. So the court is saying Article 31B, which we assume to be constitutional, the court could not have pronounced on its constitutionality for the simple reason that it wasn't challenged. But without pronouncing on the constitutionality, the court did pronounce on the scope of protection which it believed to be afforded by Article 31B, and which was to be a limited exception, not an unlimited exception. So much so to exclude the judicial review by the judiciary. The court also made a distinction as part of its reasoning, the necessity in a written constitution of a judiciary and the fulfillment of that necessity by the judiciary. So if you allow this provision to be an unlimited one, so anything that is declared legal will be put in ninth schedule. And it's a very strong language has been used by the court. That is outside of the discussion, but I should tell you, Parliament has created its legislative hegemony. This is a very strong language that has been used. Very strong, strongest expression that I have found in the text. Legislative, parliamentary, not exact expression is parliamentary hegemony. So this is about it. So original intent. Just one comment on this. This would mean when you qualify the word intent by original, earlier we said, Scalia said, intent may be objectified only by words, but when you qualify it original, which means that intent, when it was formed by the words whatever were used at the time of expressing it for the first time, was not the final expression of intent. Original means this intent is subject to evolution. and specifically in the context of a constitution. Constitution is a written law if you have a written constitution. But that does not make it just another instance of a written law. There is a Motor Vehicles Act, and that is also a written law. There is a difference between this written law and constitution as written law. I mean, obviously, consumer protection is a written law, and constitution is a written law. So you can't compare both simply because both are written. That is the point that the constitution, that the code of constitution says. Further explanation. When we talk about interpretation as determination of intention, there are two assumptions that we are making. Now, we are making further analysis on the basis of, we have introduced some literature and then again we are revisiting the concept. Two assumptions that you find. First is the assumption of the existence of legislative intention, whether it is of those people, parliamentarians, or of the legislature. You are certainly assuming that there is an existence of intention, such a thing that exists. We are not debating it whether this is, because that is a separate class. Just as the court presumed Article 31B to be. So we are saying that, well, those who talk about intention in the context of interpretation necessarily assume that there does exist intention. Second assumption is the assumption of the ability of the judiciary to discover it. Obviously, you believe the judiciary is so able, then this intention may be discovered by the judiciary. Two assumptions are necessary. There could be other assumptions, and I know there are other assumptions also, but these are two fundamental assumptions on which there is no, you see, disagreement in the literature. Two basic assumptions are made. Now we move forward from intention to meaning. Those who believe that interpretation, you see, as an end, as a product, is not the determination of the intention, but the determination of meaning. At least there are two illustrations. One is a case which I did not forward to you. I thought you would not be able to read this much of. That was one reason. Second is that this case, I am sure you must have heard of this case, but we will read the original text, which I don't think you have read it in your LLB classes, in the original. But you will read it in this class, this series original, when we discuss it in an appropriate context. That is why full reference is given. I tell you the citation, what is the essence of it. In this case. And then you have one judge, very celebrated, Justice Oliver Wendell Holmes, and I am relying on the writing that is there mentioned in the readings. Theory of interpretation. 19, whatever, Harvard Law. Roscoe Pound, chapter 3, is philosophy. What these people are saying. Gray versus Pearson. The judge is saying, if you say intention, there are two problems. One, two. Whether it refers to the intention of the person who made the will, because it is in context of the will. Doesn't matter, it is written text. The person who made the will, or the intention of the person in using the words. What intention? So the judge is saying it is very difficult. And then he is suggesting a solution. He is saying, well, that gentleman is not here before us, he is dead. The person who made this will is dead. We are not speaking to him. We are not hearing from him. We are hearing from him through the text. So realistically, if you want to discover intention, it is only by reading the text. Because speaking to him is not possible. No internet, no mobile can connect to a person who is not there. You can connect to a person in 1 minute, a person who is in the United States, who doesn't exist. I don't think there is a technology, so I am safe to say that it is not possible. There may be a technology, I don't know. Then, Holmes. Holmes is again saying the same thing. Holmes is very categorical, and Holmes' language, as you know, is very well known for the use of exactly the opposite of Justice V.R. Krishna Iyer. He would communicate the most difficult thought in perhaps the most simple language. That was the beauty of Oliver Wendell Holmes, well acknowledged, and also of H.L.A. Hart. which even people at, you see, Harvard have acknowledged this. We will refer a text in some context and then we'll talk about it. Holmes said, we do not talk about what the legislature intends. We talk about what the text legislation means. Intents and means. Very simple sentence. This is how Holmes is referring to, because he is an exponent of the meaning approach of the intention of the legislature. Then Roscoe-Pound. Roscoe-Pound also follows the same thing. Roscoe-Pound is also saying, well, we only talk about the meaning, not about the intent. Because before us, there is the evidence that we have. We have to appreciate evidence. A court of law, the function of a court of law is to appreciate evidence. And the evidence before us of intention is the text. So therefore, we have to say what the text means, and what the text means is what is intended. That is how we have to go about it. So this is basically the approach of those who. This is explanation one of the meaning. Another explanation, another very important evidence of this meaning approaches, that is very important if you see from the international law point of view. Articles 31 and 32 of the Vienna Convention on the law of treaties talk about meaning. They refer to the meaning. If you see the expressions used, it does not talk about intention. It talks about meaning. So you can see on international plane, remember arbitration case, boundary case that we refer. You know what was it? It was of 1904 or 14. Vienna Convention 1969, approximately more than 50 years. In 50 years, the jurisprudence on the international plane has moved. Well, obviously at that point of time, there wasn't existing a treaty. Well, the tribunal did refer to a couple of laws in force in some of the parties, in Portugal, in Austria, in Germany, in Netherlands. But certainly there did not exist a treaty which would refer to a rule on interpretation. So this is, you see, the importance of, you can see Articles 31 and 32, very important, because they talk about meaning. They don't use the expression intention. The third thing which I would only indicate just to complete the argument, but I will not discuss it because most of it is going to be discussed in this series, but just to complete the argument. When we talk about meaning, you have to presume that meaning is to be conditioned necessarily by the context, by the purpose, by the system, by subsequent consideration, and any other relevant consideration. In other words, there is no meaning of a law, a written law, which is without these considerations. The reason is very simple. Problems of interpretations arise in a real world. They arise in the factual matrix of a real case. So there can never be an abstract interpretation. This is the importance of this. When we talk about meaning, so you have to read these considerations. Of course, these are going to be the subject matter of our class. Meaning is conditioned by, you see, further by, why I is written further, because those two considerations, language and grammar, I have already said in the beginning. If they condition the meaning of interpretation, certainly they condition interpretation. So linguistic consideration we have excluded. So you have contextual consideration, you have purposive. You don't have to write it, we will see it, systemic, subsequent and other considerations. Interpretation is both a product and a process. That is our first conclusion. So I started off at 4 o'clock, so it is 10 past 5. So I think I have reasonably completed your lecture in 1 hour. So we started at 4 o'clock. So interpretation is both a product and a process. That is our first conclusion. Our conclusion 2 is, and that is the explanation of the first, interpretation as a product is a judicially determined intention of the enacted or agreed law or its makers, or meaning of the enacted or agreed law. Our conclusion 3 again is the explanation of the first conclusion. Interpretation as a process is a judicial process of determining intention of the enacted or agreed law or its makers, or meaning of the enacted or agreed law. Now we are available for any discussion, you see, that you may have, or the comments by sir. The floor is open and questions are all questions are. Yes, please. Give him mic.
Sir, can you repeat Holmes' interpretation again? As in you said, Holmes said that legislation, we have to look at what the legislation means and not at the intention.
Yes.
Okay, my question is that if you are looking at the meaning of the legislation, isn't the intention, will not the intention be also a part of the process? I mean, how do you arrive at the meaning without knowing what the intention is?
You see, it is the other way around according to Holmes. Holmes is saying only by knowing the meaning can you be sure of the intention. Put it conversely again according to Holmes. I am explaining Holmes. This is not my reply. Holmes is saying it is only by knowing the means can you be sure of the intention. Still differently, in order to know intention according to Holmes, you have to read the text and know the meaning of the text. There is no intention of the legislature which is not incorporated in the meaning of the text. He said it. It's very straightforward statement. We inquire not what the legislature intends, but what the text means. Straightforward. There is no ambiguity about this. Clear, straight sentence. You see, he also said it. You see, let me also tell you, if you really want to know more about of him, I'm not saying that no person's entire philosophy of looking at law, and certainly a person who has been a judge for so many years, could be confined to one particular sentence. But since the question was specific, so there must be an end to the answer. I cannot tell you about several articles that he read. But I would request you to read also, thank you, to read also the article by Holmes that was published in Harvard Law Review, 1897, on his most celebrated talk that he ever gave to law students. Boston College of Law talk, the Path of the Law article. And in that Path of the Law article, you can get an extended answer of this, where his thesis of realism is exemplified. You see, remember, where he says, he himself is giving a logic. He himself is giving a logic when he says, we inquire not what the legislature intends, but what the law, what the text means. This is a logical approach. Why? Because the evidence before the court is evidence of intention is only the text. In fact, he is applying logic. But you know what he said of logic? 2 years before writing this. This was published in 1899, if I correctly remember. And that he said in 1897 about logical method. He says logical method is a fallacious method. if in his own words, if I can roughly reproduce for you, he said logical method and form flatter that longing for certainty and for repose, which is in every human mind. But certainty generally is illusion, and repose is not the destiny of man. Behind a logical form, this is important, behind a logical form lies a judgment as to the relative worth of competing legislative grounds. Often an inarticulate and unconscious judgment, but it is the very root and nerve of the whole proceedings. You can give any conclusion a logical form. Prophecies of what the courts will do in fact, and nothing more pretentious are what I mean by the law. So in fact, if you see this, so this is what he had said before saying, if you see in terms of chronology, Holmes had said this, which I explain later. But in the context of interpretation, you see, he said it. So what I would say, his philosophy of law was basically that of realism. And he said it to a common man, you know what is law? What the court says. A common man doesn't care about law. You know what he cares? कहता अच्छा क्या हो गया? मुझे जेल जाना पड़ेगा. This is then he understands law. When you understand railway law, when the TT said, okay, you are traveling in sleeper class, you have a general ticket, give me 100 rupees more. Then you realize this is law. Before that and after that you don't realize. You realize traffic rules only when you have to pay fine. This is Holmes' approach, this is realism. So he said it. So his basic, I would say that when you read a statement of opposition, if you have also access to some of the texts where he has expressed about his basic philosophy of law, I would say you'll have a much better understanding. But as far as this article that we referred, theory of intervention is concerned, he was absolutely clear. He said, well, I don't know of intervention, I only know of this. Sorry to get back to this one.
In our theory, if you sometimes the Supreme Court has applied to FODA, that is the essence of license space and essence of rights.
Yes. No, not second one. Not essence is Supreme Court applied to court test. The essence of right test, and the second was rights test. The difference was the court was saying if there is a legislation which takes away entirely and block completely fundamental right, which immunizes legislation from a challenge on all fundamental rights, then the rights test would apply. When the legislation doesn't take away all fundamental rights, does take away one right, two right, then a limited test will apply. In other words, the legislation itself is saying that it is compatible with constitution, fundamental rights, but it actually takes away some rights. Then the court will get into it through the basic fusion doctrine. Then how much of the right that it takes? Does it amount only to a form of regulation, or does it take it away? Is it possible after this bringing this legislation into force, is it possible for people to exercise their rights? If the answer is yes, obviously the legislation would survive the essence of the right test. And if the answer is that it takes away, it's not possible to exercise it, then obviously the legislation would run afoul of the essence of the right. This is how the court was saying. Sir, your comments. Unless Sir, I think I am through with the class. Yes.
Okay.
Because they, you see, they were already exhausted with their, after 4 o'clock, they were there in that part of interaction. So I thought that my duty was not to exhaust them any further than was required.